Hello and welcome to Narayana IAS. I'm Pratik, your faculty for daily news analysis. Students, today we are going to focus three most important topics from the Hindu and the Indian Express. So let's have a quick brief about the topics that we shall be discussing in today's DNA session. The first article we have taken from Hindu page number 10. Now in this article we'll be focusing on the reforms in the prison system or structure. Now, given that the Supreme Court has observed certain issues which are continuing since many years, here we are going to understand which all steps we need to take in order to reform the prison structure or system, right? So, this topic is very important from the GS2 perspective. The second article we are going to understand about the classical language, right? So, which are the five languages which were accorded the classical language status, and here we are going to understand the criteria for according languages as classical language status, right? And the importance of it. The third article, we are going to focus on the PM KISAN scheme and its key features, right? So these are the three topics that we shall be focusing in today's DNA session, right students? So let's begin with the first topic, that is prison reforms. So as discussed, this topic is important from the governance perspective, GS paper 2. Now there's a question asked in the year 2018. What is the question? The multiplicity of various commissions for the vulnerable sections of the society leads to problems of overlapping jurisdiction and duplication of functions. Now, this topic is not directly related with the current topic or the topic that we are going to discuss, but the National Human Rights Commission. How it is responsible to ensure the human rights of the prisoners in our country, right? That's the reason a question of this nature can be asked in the UPSC examination. Let's focus on the context. Here the Supreme Court has directed whom? The central as well as the state government to revise the prison manuals. Prison manuals and rules to prohibit caste-based discrimination, which means the prison manuals. Now every state have got their own prison manuals, which means how the prisons in that respective state should be governed or function is something that is mentioned, or the rules are mentioned in the prison manuals of every state. Now prison, the subject prison is a state subject, is a state subject, which means the states are responsible for ensuring reforms in the prison system, right? Now the prison manuals, right, or the practices or the rules mentioned in the prison manuals are rooted in the colonial times or colonial practices, which means some of the rules mentioned in the prison manuals were introduced during the British times, and these rules are being continued since the British times. Now these rules, right, some of the rules are actually discriminatory in nature, which means we'll discuss which are these rules, but these rules are actually discriminatory, which means these rules discriminate the prisoners, the people who are behind the bars on the basis of caste, which means we have reported caste-based discrimination in the prison manuals. The Supreme Court is nudging, pushing the government and requesting the government, or ordering in fact, to revise the prison manuals and end discrimination, caste-based discrimination. Why? Because these manuals or these rules are rooted in the colonial times, or the evolution of these rules is tied to the colonial times, right? And these oppressive practices, right, the oppressive practices or rules, they are rooted in the colonial practices, and these rules actually dehumanizes prisoners. The prisoners who have committed a crime or their uh, crime is yet to be proven, the under trials, they are human beings. Yes, they have committed a crime, that's the reason they are behind the prison. That doesn't mean the fundamental rights of these people should be violated. Yes, they have committed a crime and that's the reason they are sent behind the prison. But still, they have the right to live with dignity. And the Supreme Court ruling seeks to eliminate such discriminatory practices, right? This is the context. Now, let us try to understand more about this particular topic. Now, the Supreme Court, right, while ruling or while ordering the government to revise the prison manuals, observed certain issues in the entire prison ecosystem. For example, overcrowding, more number of prisoners in a jail or let's say in a prison, and then lack of medical care, inadequate access to legal aid, legal help. Now, these issues, if we see, it violates the fundamental right of Article 21 of the prisoners, which guarantees each and every human being a right to life. And this life should be dignified life. If the life is devoid of dignity, then that's not what we understand or call life or living a life. So, the life has to be attached with dignity. Every person has the fundamental right to live with dignity. And that's the reason in the year 2018, the Supreme Court had set up a committee. Now we'll understand about this committee in the slides, right? The state government, the Supreme Court has urged state government. Why? Because the prison, this subject falls under the state subject, and that's the reason the Supreme Court has urged the state governments to adopt measures, thereby ensuring that the reforms are carried out comprehensively, right? Now, let us try to understand the status of Indian prisons. India has around 1400 prisons in our country. We have 1400 prisons. Now, a total of like 5.5 lakhs, around 5.5 lakh prisoners were confined in Indian jails as of 2022. This is the data of 2022, which means we have around 5.5 lakh prisoners in the Indian jails. Convicts, which means whose crime has been proved in the court, which means the court has believed and passed a judgment sentencing an accused person to jail, which means it is proved that this person has committed a crime and is being sent behind the prison. This is what we understand by the term convict. See, let's try to understand the meaning of under trials, detainee and convicts. Let's say, for example, this person has committed a crime. A person has committed a crime. Now, this person B accuses A, right? Blames A, saying that this person A has committed a crime. This person B approaches the police station, right? And tells the police officer that this person A has committed a crime. Based on the prima facie evidence, which means prima facie, based on the available evidence, right? The police will send this person or arrest this person. Let's say now the police has actually lodged this person A in the jail. The police has to bring this person A in the court within 24 hours, right? Now here this person A will be brought before the judge. So this person A stands before the judge. The judge will ask him, have you committed a crime? Which means now this person A, if he says, yes, I have committed a crime, then this person will be sent to judicial custody. See, there are two types of custody. One is the police custody and the second one is judicial custody. What is the difference? When an accused person is launched or lodged in the jail managed by the police jail, that is what we understand by the term police custody. The jail which is managed by the police. Judicial custody. Now, judicial custody will be under the control of the courts. Now, if this person says that yes, I have committed a crime, then the judge will possibly sentence him to judicial custody or police custody, either of this. That's a long procedure, but here you need to understand that police custody is the jail which is managed by the police. Judicial custody is under the control of the courts. Now, let's say this person says that I have not committed a crime, which means now this person, to defend this person, there will be a defense lawyer. And to defend this person, there will be a prosecution lawyer. Why? Because B is prosecuting A, is accusing A of committing a crime. Now, their lawyers, this person's lawyer and this person's lawyer, they will argue before the judge. This defense lawyer will try to prove that A has not committed a crime. This prosecution lawyer will try to prove that A has committed a crime. Based on the evidence, the judge will finally decide if this person has committed a crime or not. Let's say, for example, the judge pronounces that yes, A has committed a crime, so he will be sentenced to a jail term of 5 years. This is known as convict. When the judge punishes a person, the guilt or the crime of a person is proved in the court, then that person will be referred to as convict. Let's say the judge realizes that this person has not committed a crime, which means the charges the B has accused against A are false. Once the judge realizes this person has not committed a crime, right, the judge will release him. This is known as acquit. The opposite of convict is acquit. Convict and acquit. Now, when the proceeding is going on in the court, it takes months, years, which means until the judge pronounces judgment, until the judgment is given, this person has to stay in jail, or he can also be released on bail. Let's say, for example, he is a very poor person, he has no one to defend. So the judge has to force, or the judge forcibly has to send this person to jail. He is known as under trial. Under trials are those people whose crime is yet to be proved, which means under trials are those people accused of doing certain crimes, but their crimes are yet to be proved. We have heard that in India, to dispose cases, it takes years. So the time until which the judgment is given, these people have to stay behind the jail. These are known as under trials. So convicts, acquits and under trials. Detainees are those people where the government actually detains a person, which means they are not actually sent behind the bar or sent to jail, but they are actually confined to the place they are staying. It can be house arrest, or let's say the governments have certain locations wherein people whom the government considers that these people might create a law and order situation or might disturb the peace of the region, these people, which means these people have not committed a crime. Detainees are those people who have not committed a crime, but the government fears that these people might do a crime. right? In order to prevent a person from doing a crime, the government detains people. This is known as detainers. I hope you understood the difference between convict, acquit, under trials and detain or detains, right? So out of 5.5 lakh, 22% are convicts, which means the crime has been proved. 78%, 77% are people who are under trials, which means their crime is yet to be proved. And these people are mostly poor people. Majority of these 77% are poor people. They have no lawyer to defend themselves. As a reason, they have to send or they have to spend much of their life behind the jail. And 0.6% are detainees, right? These are some statistics. Please try to make a note of the statistics, because it means the more you mention stats and figures, it will help you to get good marks, right? Now let us try to understand the issues and challenges in the Indian prisons. First is overcrowding, which means the Indian prisons operate at 130% of their capacity. The capacity is to accommodate only 100 prisoners, but they are accommodating 130 prisoners. Due to the high percentage of under trials, I have explained you what one understands by under trials. It undermines, overcrowding undermines prisoners' access to basic amenities such as healthcare and food, as well as proper living conditions. Why? Because let's say, for example, a prison has the capacity to hold only 500 people, but there are more than, let's say, 600 people in the prison. So let's say the healthcare facilities, food, all this falls short, and that's the reason living condition becomes a big problem for the prisoners. Understaffing, a 33% staff shortage in prisons, particularly in correctional roles, hampers the management of inmates. Inmates are the people who are behind the jail. Now, what do you mean by correctional roles? Students, it is very important to understand the concept of prison. What is the concept of prison? Why are prisons meant for? Why are people sent behind the prison or jails? Is it only because to punish these people? Yes, punishment is one purpose. See, the purpose of sending behind the jail is for the sake of reformation. Now, please understand this reformation. Let's say a person has committed a crime, right? He's sent behind the jail. He's lodged in the jail. Now the society is trying to help that person to reform himself. It's not as simple as we think. Which means here the society is helping, which means the state is helping the person to or is helping the people to reform themselves. For example, a person has murdered someone, killed someone. Have you ever considered the circumstances under which a person has committed a crime? For example, let me give an example so that you better understand or you can relate to the example. There are two people, A and B. There are two people. Now, this A person has all the basic amenities. For example, he has parents, okay? Parents, then he has the access to food, education, proper home, friends, friend circle. Which means if you see this person, he is in a position to access all the basic necessities to live a dignified life. This person. Now, this person B is born on the streets. He is a beggar. He is a person born on streets. He has no idea who are his parents. He lands up in slums with no parents, right? In slums, you know the condition, no hygienic food, education is virtually absent, there's no education, no proper home, the friend circle is not good. For example, if you are educated, you know that, committing a crime is a wrong thing, which means proper values, correct values have been embedded in you by your parents. So parents, for example, parents, school, they help you learn the right values. You learn the right values, you understand it is wrong to, let's say, lie a person, or let's say harm a person, commit a crime, which means all the basic necessity or values have been given to you, this person A. And that's the reason there's a less chance, minuscule chance of this person A committing a crime. But what about this person B? He doesn't know what is right and what is wrong. Why? Because he has no parents. There's no education to him or education given to him. So he doesn't know what is right and what is wrong. Then he comes across friends who are of his age, or let's say elders to him or older than him, and they teach him all the wrong things. So the chances of this person B committing a crime is more than this person A. He doesn't know what is right and what is wrong. Why? Because no one has taught him what is right and what is wrong. His parents, let's say, forget parents. Why? Because parents, let's not talk about parents now. Let's talk about the society. The state. The state should have helped this person to get education. The state should have ensured that this child, this person who was a child once, the state should have ensured that this child B receives proper education and proper food. Unfortunately, the state failed to give him education. That is the reason we have state, right? The people who are helpless, we vote and we elect a state, elect a government, so that the government helps people who are helpless, right? So the state, the society has failed this person has committed a crime, everyone is blaming this person B. The purpose of prisons is to send this person behind the jail and help him to reform. This is the purpose of the prisons. Punishment is one purpose, but the ultimate purpose is that the state will help him to reform and then rehabilitate and then reintegrate in the society. Which means now this person is sent behind the jail. There will be mental counseling, psychological counseling. He will be given some training, let's say vocational education, skill development, skill training, which means once he's in a position now behind the jail or in prisons, the system will help him to make him a better person. He'll be provided skills, psychological counseling, mental counseling. All these proper values are given to him. Now, when this person comes out, he will come out as a reformed person and will be reintegrated into the society. And then he'll contribute to the society. Why? Because once he has skills, once he has knowledge, he will use that skills, to get a good job. By getting good job, he'll earn money, he'll spend money. This is how he'll contribute to the economy. This is the concept of prisons. But unfortunately, students, the people who are sent to prison, they become actually dreaded criminals. It is said that the prisons are a den of all the illegal activities. You can read the reports, you can search it on internet. It is considered that the prisons, the jails, are considered to be dens of corruption and illegal activities. Smuggling, drugs, substance abuse, everything is very common in the jails. You must have seen in the movies, right? Unfortunately, this is how the state of affairs are solved. Very bad, very pathetic. I hope you understood the concept of rehabilitation and reformation. Rehabilitation, you provide him skills, vocational training, skill development, education, and once he's reformed, he'll be sent back to the society as a reformed person. This is what we understand by correctional rules. Correctional rules are those rules who help people to rehabilitate and reform. For example, psychology, or let's say psychologists. These people help the people who are behind the jails or the people in the prisons to reform. They'll help them in reforming. These are known as correctional rules, will help the prisoners to reform. I hope you understood the second point. Third, poor living conditions, lack of proper sanitation. There is no proper sanitation. Health services and overcrowded sleeping arrangement, it leads to health diseases like the hepatitis and jaundice. Third issue. Custodial deaths, custodial violence and torture and deaths, particularly suicides, remain serious concerns. Experiencing horrible conditions in the prisons, few prisoners who are not in a position to absorb brutal treatment, they commit suicide. Or at times, the police, they torture a person to an extent that the person dies in the jail. I am talking about custodial death or custodial violence is when the police beats up a prisoner so much that he succumbs to injuries and dies. Then there is ambiguity in categorizing deaths as natural or unnatural, which means, for example, custodial death. The police will mention that it is a natural death. Or let's say a person committing a crime, or let's say a person committing suicide. The police will report that it is a natural death. This person committed suicide. But actually this person was forced to commit suicide. So this should be actually unnatural death. But there is a confusion, ambiguity with respect to categorization of deaths as natural or unnatural. Which means if a person is forced because of torture to commit suicide, that is actually unnatural death. But somehow in order to make the case easy, the police reports it's a natural death, case dismissed. Next, mental health issues. Now a person, once he spends a significant amount of time in prison, in jail, that actually affects his mental stability. That's the reason psychological counseling is very, very important. The health condition of the people who are lodged in jail since months and years, it actually takes a toll on their mental health. Next issue. Women prisoners, they face several challenges like, for example, lack of female staff. There are also cases of sexual violence against prisoners, inadequate hygiene, especially during menstruation cycle. They need hygienic condition, atmosphere, and then higher vulnerability to custodial abuse, that is abused by the police. So these are some of the issues that the prisoners are facing or going through. Now, historical prison manuals, that is the prison manuals framed during the British times. We discussed that the prison manuals were framed or developed during the British times and they are discriminatory. Why? Because it's written in the prison manuals that food can be prepared only by the prisoners belonging to certain caste. Or let's say the sanitation work, the menial work, the drainage work. This work will be done by people belonging to a certain caste, especially traditionally lower caste people. Which means what kind of job should be done by which kind of caste is something that is written in the manual. Which means the manuals, the rules written in the manuals are discriminatory. This is what the Supreme Court is urging the state government to change. Though reforms have been undertaken and there are certain changes in the manuals, but somehow we experience that subtle biases still exist. And that is what the Supreme Court has pushed or urged the states to reform or to change. So I hope you understood all the issues. Now let us try to understand this Model Prisons Act 2023. Students, whenever you observe my lectures, right, I try to include as many dimensions as possible whenever I am explaining a topic. The purpose behind, for example, when it comes to the prison reforms, I explain what is the context, I explain the observation of the Supreme Court, then I helped you with the status of the prisons in our country, then I explain the issues and challenges. Now we are understanding the Model Prisons Act 2023. Then we will understand the various committees and their suggestions to reform the prison structure. Then what we can do in order to reform the prisons comprehensively. So if you look at the dimensions that I'm covering, they are diverse, they're holistic. Why? Because the more dimensions you cover in the means examination, means answer, the more marks you'll fetch. And that's the reason I try to cover as many dimensions as possible so as to help you to address many dimensions in the answer. And trust me, by developing a habit of adding many dimensions, you'll be in a position to get good marks in the examination. Okay, now Model Prisons Act. Now what is this act? This act actually aims to replace the outdated Prisons Act of 1894, focusing on the rehabilitation and reintegration of prisoners into society. This is what I explained in the previous slide. Right? The purpose is to rehabilitate a person and reintegrate that person into the society. How? Through vocational training and skill development. I explained this point, right? Use of technology. Here we need to use technology like video conferencing, biometric identification and CCTV surveillance to improve the prison management, to ensure that there is no custodial torture or custodial death, or let's say substance abuse. Special provision for vulnerable groups like women. For example, we can have separate accommodations for women and the transgender for their safety and well-being. Make sure that you know this act and 2 to 3 points under this act. Then security and rehabilitation includes security assessment and segregation of women based on risk levels, as well as individual sentence planning to support reintegration. Next, provisions for legal aid, parole and furlough. What is legal aid? For example, if a person is poor, then here the state helps that person with a lawyer. Legal aid. What is parole? Parole is temporary release from the prisons, which means on account of good behavior. Let's say, for example, a person is sent to 5 years jail term. Now, upon observing his behavior for 3 years, if the prisoners feel that this person is actually behaving nice and is helping the authorities, then this person will be released temporarily from the prison for some time on account of his good behavior. For example, Sanjay Dutt, Salman Khan, they were released on parole. Furlough. What is furlough? This is again another form of temporary release from the prison. This actually is a right of the prisoner. Let's say, for example, if a prisoner wants to seek mental health or mental support or health support, the correct word is health support. Or let's say there's some family emergency, health emergency. Now, in this case, the system of a country allows a person or allows the authorities to release that person from jail for some time. It is temporary. Furlough is a right of a prisoner. Parole is not the right of a prisoner. This is the difference. Next, grievance redressal mechanism. It establishes a system for addressing prisoner complaints and a prison development board to monitor improvements in prison conditions. So, there is a board that monitors the improvements in the prison conditions. These are some of the characteristics or features of the Model Prisons Act 2023. I hope you understood all the points. Now, these are some committees that the government had set up in order to reform the prison system. Very, very important that you mention 2 to 3 committees and their names. The most important is the Justice Mullah Committee, right? This committee was constituted in the year 1983. It recommended what? The formation of national prison policy. Here, the policy should be universal. The policy should be standard, right? Rather than having a state specific policy, we need to have a national prison policy, national policy. Creation of an all India cadre for prison staff. Just like we have IAS, IPS, IFS, we to have an all India cadre for prison staff. And the use of alternatives to imprisonment like community service. So if a person has not committed that big a crime, rather than sending him behind the jail or in jail, he should be made to serve the community service. The next is Justice Krishna Iyer Committee on Women Prisoners, advocated for separate institutions for women, staffed only by women. This is very, very important. So, if you do not mention this committee, this one and this committee, if you do not mention, if you forget to mention these committees, trust me, like half to 1 mark will be cut. This committee. It suggested reforms like setting up fast track courts. Why? Because in order to dispose cases of under trials, 77% of the inmates are under trials. So, in order to give them justice, fast track courts should be set up so that cases are heard as soon as possible and the cases are disposed on its merit. Improving lawyer to prisoner ratio. Now, this is a homework to you. In the statistics, also mention what is the current lawyer to prisoner ratio. This is your homework and I request you to answer the current lawyer to prisoner ratio in the comment section. What is the current lawyer to prisoner ratio and what should be the ideal lawyer to prisoner ratio? If you are listening to this video, make sure that you are commenting in the comment box the correct answer. Model Prison Manual 2016, it provided comprehensive guidelines on the prisoners' rights. Which rights? For example, they should get legal aid, right? Living conditions should be better, education, mental support, all this facility should be given to the prisoners. Now, these are the initiatives taken for the improvement of the conditions in Indian prisons. These are very factual in nature. So, first one is the e-prisons project. It aims to streamline prison management through digitization, which means here the prisons will be monitored or managed through digitization. That is, will incorporate technology to manage the prisons. Modernization of prisons. Here the central government will help the states with funds, financial assistance so that the states modernize the prisons. Right? Modernize, you mean as of now, the status of the prisoners is horrible. What is the purpose of sending a person behind a jail? That is, the purpose is rehabilitation and reformation. So here the central government will help the states with funds so that the state utilizes those funds to rehabilitate and reform a person. Open prison system. What is open prison? Now, if you look at the jails, these people have to follow a strict regime. For example, they have to wake up at a certain time, right? Then they have to do some work. Then they have to, there are timings mentioned for having food, doing work, etc., etc., right? So, open prison system, which means the rules are not as rigid as the people who are lodged in traditional jail. The rules are not rigid, which means they are given freedom and responsibility, right? So, this is known as open prison system. So, here the concept is, or the suggestion is, expanding open prisons where prisoners live under minimal security, that is, they have more freedom. Fast track courts we discussed so that the cases can be disposed as quick as possible. E-courts project, right? It aims to reduce case pendency, which means here we are incorporating using technology to reduce the number of cases, especially for under trials. Now, way forward again. The issues that we discussed, the same points you can convert into way forward. For example, the first one is technology integration. We can use CCTV, biometric identification, video conferencing that will enhance the management of the prisons, right? So that through this technology will ensure that the rights of prisoners are not being violated. They are kept under continuous surveillance. Expand open prisons. We have discussed what is open prisons. Then strengthen legal aid services, parole, furlough, helping the under trials with a lawyer, state appointed lawyer, right? Mental health focus. We need to have psychologists who can provide mental counseling so that we prevent the prisoners from committing suicide. And these counselors help a person to reform themselves rather than turning more brutal and more violent. Here these counselors will help a person to reform. Then reducing under trials, we discuss this, public and official mindset. So there has to be change in the mindset from punitive approach to rehabilitative practice. For example, whenever a person commits a crime, the public start demanding that this person should be executed, killed straight away. This is not how it works. You should understand the situation, circumstances. Because by executing a person, we are not going to solve the problem. If you want instant justice, fine, execute a person. But if you want a long-term solution, then the mindset has to change from punitive, that is punishing a person, to rehabilitation. Which means here the common people like us should force the state, should push the state to help these prisoners to rehabilitate and reform. We should actually help or push the state, the governments, the state government, central government, local governments. We should actually push these state governments, or let's say the governments, so that the governments invest sufficiently in health, education, especially taking care of the people who are born on the streets or who live in the slums, to ensure that the conditions in the slums are better, so that people have access to dignified life by providing them healthcare, food, nutrition, vocational training, skill development. So the mindset has to change. Only then we'll grow as a nation. So this is the first topic. I have covered all the dimensions. Make sure that you are revising and recalling all the points. Maybe you can discuss all the points that we discussed with your friends rather than gossiping about certain unimportant things. What you can do is, once you listen to the topics, you can discuss it with your friends so that whenever you discuss, the points get ingrained in your mind, and this will help you in your examination. More you discuss, rather than wasting time or talking about unwanted things, you can discuss about something really important so that it will help you in the examination. Next topic is, which are India's 5 new classical languages, and what does a tag, or once a language is accorded the status of classical language, what does it exactly mean? Why do state governments push the central government to accept their language or give their language the status of classical language? Let's try to understand. So, a question was asked in the year 2015. Which one of the following was given classical language status recently? So, next year the question will be the same. Let's assume that the question will be the same. Which one of the following was given classical language status recently? So, if you have attended this lecture, this topic, trust me, you'll go right with this particular question. Let's try to understand. Which are the 5 languages that got the status of classical language? Marathi, Pali, Prakrit, Assamese and Bengali. These are the 5 languages. Make sure that you know all the classical language status, not only the recent but also the first language that was accorded with the status, second, third, fourth, fifth, sixth and until the last. First was Tamil. right? So this is the status. 5 languages. Please remember these 5 languages. Now, this is important. When and how the concept of classical language arise? This concept of classical language emerged in the year 2004 under the Congress UPA 1 government, right? The Tamil was the first language to receive the classical language status. Simple. Why? Because of its rich antiquity. It's considered to be one of the oldest languages, right? And literary tradition. The Linguistic Experts Committee under the Sahitya Academy was set up. So once see, what is the process? The state government, let's say the Maharashtra state government, sent a proposal to the central government requesting the inclusion of Maharashtra into the classical language status. So this experts committee under Sahitya Academy Award, this committee will look into the proposal, will try to consider, understand the antiquity of the language based on, meeting the criteria. And if this committee comes to a conclusion that yes, this particular language meets all the criteria, which are the criteria, we'll discuss this. Then this committee will recommend the government to accept or refuse the proposal. Which are the other languages? Sanskrit, Telugu, Kannada, Malayalam and Odia received classical status between 2004 and 14. So 1, 2, 3, 4, 5, 6. There are 6 languages plus 5. 11 languages were accorded classical language status. So Tamil, Tamil Nadu, Telugu, Andhra and Telangana, Kannada, Malayalam. So like the southern states are covered. So it's easy for you to remember. And if you see the border of Andhra Pradesh, Odisha, that is also included. Maharashtra being included. The border of Odisha being West Bengal, even Bengal is recognized as classical language status. So this is how you remember the classical language status. All the southern states are covered. Then their borders, Maharashtra is covered. Yes, Maharashtra is covered. Bengal is West Bengal. Bengal is covered. Right? So this is how you actually remember the languages. Now, this criteria is very, very, very important for your UPSC examination. UPSC may ask you a question asking you the criteria. Which are the criteria used to accord a language with the classical language status? First is high antiquity, which means the language should be considered old, which means the language should have early texts. Old, which means it should be at least 1500 to 2000 years old. This is what you understand by high antiquity. A significant body of ancient literature or texts that are regarded as cultural heritage by successive generations. For example, the manuscripts, the transcripts. Epigraphic and inscriptional evidence. Epigraphic, the one that is written on stones, inscriptions on stones, metals, coins, right? Then availability of knowledge text, especially in prose. What is prose? It's like story, essay and poetry. We all know what is poetry. And the language and its literature may be distinct from modern forms. So these are 1, 2, 3, 5 criteria. I request you to remember each and every criteria. Why? Because if the language or the classical language status was accorded to the 5 languages, there's a high chance that UPSC might ask a question on classical language the next year, which means there are few months remaining, right? May, around how many months are remaining? The time will fly by. So there's no time for you to, think and brood and, just keep on thinking. No, you have to act and work fast. That's the reason I insist my students to always make notes. Notes in the sense you have magazine, yes, but whenever you come across important terms or concepts like this, try to make a note of it. Yes, this news is important. It appeared in the month of, let's say, October, right? So make sure that you remember all the 5 criteria. Now, what is the benefit? There has to be benefit. That's the reason the state governments actually request the central government to help their language with classical language status. Yes, isn't it? Yes. So the benefit is that the national and international promotion, which means the Ministry of Culture will ensure that the classical language will be promoted not only nationally but also internationally. This is the benefit of according a language as classical language. You get international and national recognition. And for the same, to promote the language, the central government will establish academic and research centers in prominent educational institutions like, let's say, the JNU, right? Then it will be supported from the national education policy. Why? For integrating the classical language into school education, which means your students know and learn these are the classical languages. Then creation of digital archives for manuscripts and texts. These records should be saved for perpetuity, and then broader recognition. So these are some of the advantages a language gets when it's included into the category of classical language. So which are the 5 languages? One, criteria is another important thing. Third one is the benefit that the classical language enjoys upon recognized as a classical language. I hope you understood the second point. Now let's focus on the third topic. PM to release KISAN scheme funds today in Maharashtra. Maharashtra, why? Because there are elections due in the state of Maharashtra. That's the reason you see Marathi. No doubt Marathi is of course a very ancient language. It meets the criteria, but there's also a political tone or political flavor to it. Again, here the PM is releasing funds in the state of Maharashtra. Why? Because the elections are due. A question asked in the year 2020. Now, farmers actually they play a very important role in our country. And given the importance of farmers and given the importance of the farm sector, the government is coming up with many schemes and policies, schemes for the betterment of farmers. So this topic always is in trend, relevance. So make sure that all the important facts and information, policies, schemes uh, regarding the farmers or the farm sector is something that you know and by heart. You can use this in the essay, you can use this in the GS2 paper, GS3 paper, in your optional paper maybe. So make sure that you are well equipped with all the information relating to farmers. One such information is the PM KISAN scheme. Now, we discuss what is the context. The PM is releasing the funds under the PM KISAN scheme. Now, let us try to understand what is PM KISAN scheme. It was launched in the year 2019. It became effective from the year 2018, but just remember the year it was 2019. Nodal ministry, Ministry of Agriculture and Farmers Welfare, very important. Each and every point, students, under PM KISAN scheme, make sure that you remember each and every scheme. So to remember all these features, it is important that you invest a considerable amount of time for revision. Objectives. What is the objective? To provide income support to all land holding farmers. Now these are the key terms that the UPSC would try to use in order to confuse you or simply twist the statement. For example, to provide the PM KISAN scheme provides income support to all the farmers irrespective of their land holding. Incorrect. Only to all the landholders in the country, to supplement their financial needs for procuring various inputs. For example, farmers, you all know that we live in an agricultural country, which means you should know how or what are the problems the farmers face. For example, whenever a crop has to be sown, the farmers need input cost. So there is some input cost, for example, seeds, fertilizers, right, water, right, then maybe a tractor. So these are some of the input costs every farmer has to bear in order to make sure that the sowing is done properly and efficiently to expect a good output or outcome. Now, most of the farmers, to meet this input cost, they take money from the money lenders at a high interest rate of, let's say, 30%, ranging from 30 to 50%, at times 60%. Here the government is actually helping the farmers and helping the farmers with their income support by providing a certain sum, a certain amount of money. Related to agriculture and allied activities as well as domestic needs. So make sure this term is important irrespective of the size of the land. Another very important term or word which the UPSC might use to confuse you, twist you. So make sure you are informed with this particular fact. Central sector scheme, which means there is no contribution from the states. Two types of scheme. One is the central sector scheme where the central government provides 100% funding. The other one is centrally sponsored scheme where the central government as well as the state governments contribute. For example, it might be, let's say, 50-50, 60-40, 70-30, 90-10. Central government, and this is state government. This is central sector scheme, which means funding is 100% from the central government. All land holding farmers families which have cultivable land holding, very important as per the land records of the concerned state utility. Cultivable is important. If the land is not under cultivation, then that farmer would not get the support under the PM KISAN scheme. And what is the definition of families under the scheme? Husband, wife and minor children. Now, this criteria is not applicable for the northeastern states and the state of Jharkhand. I ask you why. Pause the video for a while and try to think why northeastern states, or for that matter Jharkhand, is not included under the PM KISAN scheme. So students, the land holding pattern that we observe in most of the states is not the same in Jharkhand and northeastern states. For example, people in northeast, or for that matter Jharkhand, have a different way of recording or maintaining the land records. Now, many of the farmers, they do not have land records registered in these states. Why? Because of the customary practice. Now, here we are literate, educated people, we do not understand the importance of documents. How can you expect that the poor, sort of illiterate, uneducated, I would rather prefer to use the word illiterate rather than uneducated. So these farmers actually do not understand the importance of maintaining land records, or somehow the system is devised in a way which actually prevents a person from registering their land. Why? Because, for example, if I say that this land belongs to me, what is the record I have? Now my ancestors told me that this particular portion of land belongs to me, and to him his ancestors told him. So this actually is customary practice that is followed in majority of the northeastern states, and that's the reason certain exemptions are given to these states, which means these criteria are not applicable to these states, which means relaxation is given to people of farmers belonging to these states. And who are the people excluded under the PM KISAN scheme? Institutional landholders, that is the land belonging to institutions and not farmers. Then former and present holders of constitutional posts like the president, prime minister, ministers. You can simply read out the list. So these are the lists that you have to remember, right? So I request you to please go through all the points that, or these are the people who are excluded from the PM Kisan scheme. And what is the benefit? 6,000 rupees per year directly to the bank account, which means every 4 months 2,000 rupees will be credited in your bank account. 6,000 rupees per year is the amount every land holding farmer would get in his or her bank account, irrespective of the land size. A person has, let's say, 1 acre of land, the other person has, let's say, 20 acre of land. Both these people are eligible. You might say that yes, there is a problem. Certainly there is a problem. A person who has 20 acres of land should not be held by the government. Why? Because he is already an affluent person, right? Now let's try to understand the features, right? Responsibility to identify beneficiary farmers rests with the states and union territory governments. So who are the beneficiaries of the scheme? The central government? No. States and the union territories are responsible. That is their governments. Cut-off date is 1st Feb 2019. Not that very important point. No changes in the name of beneficiaries to be considered for the next 5 years. Once a beneficiary is registered, his name or there will be no change for the next 5 years unless there is a transfer of land because of the death of a person. Let's say a person dies, now his land is passed on to his successor. Funds are not allocated and sanctioned state-wise. So funds are not sanctioned state-wise. Aadhaar-based e-KYC is mandatory. Very important point. Aadhaar-based e-KYC. Then the tenant farmers are not eligible. Very, very important point. Again for your prelims, make a note of this point. Tenants are not eligible. Micro land holdings which are not cultivable. As I told you, this scheme is only applicable to farmers who have cultivable land. If the land is not cultivable, you won't be a beneficiary. Agriculture land being used for non-agriculture purpose is also not covered. There is no distinction between urban and rural cultivable land. Again, a very, very important point. Then we have a PM Kisan mobile application. This is the first mobile application to use face authentication based e-KYC. And to register face authentication, people will come at your home, e-KYC at home without any OTP or let's say any fingerprint to maintain the privacy, right? Then AI chatbot, right? You know what is chatbot? So whenever you visit a website and you post a message, there's automatic reply. You must have used this using Swiggy or let's say Zomato and many other prominent applications, right? Now, first AI chatbot integrated with major flagship of the union government, that is the PM Kisan scheme. So if you visit the website or let's say application, you are free to ask any question and the AI, artificial intelligence chatbot, would reply to your question. And then it also assists the farmers in seeking information, right? All other information that the farmer is in need, the farmer would get in the application. So these are the benefits and the features of the PM Kisan scheme. I hope students you understood what is PM Kisan scheme and its features, right? And these are the three topics of the day. I hope you have understood each and every topic, made a note of all the important points, important uh, facts, right? And make sure you're revising it, rehearsing it, and if time permits, you may also write the points that you have understood in today's DNA session. Last but not the least, let's discuss few questions. Consider the following statements with reference to PM Kisan Samman Nidhi. It is a centrally sponsored scheme launched in 2019 where the funding is shared between the center and the state in the ratio of 60:40. Under the scheme, 6,000 per year is directly credited to the bank account of farmers who own up to 2 hectares of land. Third, the beneficiaries to the scheme are identified through these socio-economic caste census. Have we discussed any of these points? No. The first statement, why is it incorrect? It's a central sector scheme, which means there is no contribution from the state government. It is fully funded by the central government. So the first statement is incorrect. The second, yes, 6,000 rupees is credited per year, but this is in 3 installments. Every 4 months, 2,000 will be credited. The beneficiaries has got nothing to do with socio-economic caste census. Which of the following statements given above are not correct? All are not correct. Option D is the correct answer for question number 1. Next question, which of the following criteria must a language fulfill to qualify for classical language status, right? First is high antiquity with evidence of text spanning at least 1500 to 2000 years. Yes, this one is correct. A significant body of ancient literature considered cultural heritage. Yes, this one is correct. Continuous use of the language without any interruption. Did we discuss this criteria? No, this is incorrect. Availability of both poetic as well as prose text. Yes. So 1, 2 and 4. 1, 2 and 4. Option B is the correct answer for question number 2. The next question is the means practice question. Prison reforms are crucial to ensure justice, uphold human rights and maintain the integrity of India's criminal justice system. Discuss the key challenges faced by Indian prisons and suggest measures for reform. All the dimensions that we covered in the first topic, prison reforms, if you have understood these topics, you should be in a position to write the answer. Just for the sake of your understanding or just to help you how to write an answer, in the introduction you have to start by mentioning about the criminal justice system or about the prison reforms. What do you understand by prison reforms? It would be better if you mention certain statistics. For example, India has about 1300 jails, out of which 22% are convicts, 77% are under trials, and this data is as per the National Crime Record Bureau. If you mention this point about this and this in the introduction along with fact, trust me, you win the confidence and trust of the paper evaluator. He is happy with your introduction itself. Then in the body, mention the challenges faced by the Indian prisoners. We discussed overcrowding, inadequate staffing, mention about the role of rehabilitation, right, and reformation, custodial deaths, suicides, health and hygiene, lack of legal aid. Mention the solution, reducing under trials, integration of technology, prison infrastructure, staffing and training, technology, open prison system. So see, we have discussed all the points, so I'm not going to repeat the same points. Rather, I would want you to listen the first topic again and then be in a position to write down the answer. So introduction, mention about the prison reforms, statistics, followed by body. In the body, mention about the challenges faced, right? Then mention about the committees, right? Committees, very Amitav Rao committee, Roy committee. Then we have the Mullah committee. Don't forget to mention these committees. Mention the solution and the conclusion. Mention that in order to make sure that people in our country, especially prisoners, are living life with dignity as per Article 21 of the Indian Constitution, it is important that the Indian state, the governments focus on reforming the prison system. This is how you conclude the answer. So students, that's it from today's DNA session. I hope you understood all the topics and the questions and you're in position to address the questions that we discussed, right? Make sure that you are continuous with the DNA sessions and make sure that you are getting better day after day. That's it from today's DNA session. Thank you students so much for watching.